Good afternoon. This is Laura Genovich. I'm an attorney at Foster Swift, and I want to thank you for attending today's webinar on medical marijuana. This is a 30-minute presentation that's intended to explain what's legal, what's not, and what we can do, with we meaning Michigan municipalities. We have a great turnout today, and I appreciate that. You'll see on your screen an option to ask questions. Because of the number of attendees, we may not be able to answer all questions during the presentation, but if you do ask a question, I will be sure to respond to you by email after the presentation. So with that, we'll get started. All right. Well, as I'm sure all of you know, medical marijuana has become a controversial issue and one that has become a local issue as well. If you go to Google and type in medical marijuana Michigan townships or anything like that, you'll come up with a host of headlines about the issues that are facing Michigan communities as they decide what they want to do about medical marijuana and struggle with deciding what they can do about medical marijuana. And it's an issue that draws strong opinions both for and against, as a couple of these pictures here show. So this presentation today is going to roughly follow this outline. I'm going to talk very briefly about medical marijuana legalization nationwide and what the trends are across the country, and a bit about the history of the Medical Marijuana Act in Michigan, which was the original statute that allows medical marijuana, what is legal, what's not legal, and then the effects of the new Medical Marijuana Facilities Licensing Act, which is the new 2016 statute. Then I'm going to address what your municipality needs to do and can do, and along with some quick tips for controversial issues that your community can use for this issue or other hot topic issues. So beginning with a national overview, medical marijuana has been in the news for a number of years. And over the years, more states have legalized medical marijuana. So as of now, 28 states plus the District of Columbia, Guam, and Puerto Rico have comprehensive medical marijuana programs under which qualifying use of medical marijuana is legal and protected. So comprehensive there means it's not just decriminalized, it's that there's a statutory regimen with protection from criminal penalties, access to marijuana through either home cultivation, growing, or through dispensaries, a variety of strains permitted, and allows smoking or using other marijuana products. 89% of American adults favor the legalization of medical marijuana. That's from a June 2016 poll. And 57% of U.S. adults say that medical and recreational use of marijuana should be legal. And that's from October of 2016. So we can see the trend of public opinion and with that following the number of states that are legalizing marijuana both for medical use and on a smaller scale for recreational use. So Michigan is among the majority of states now allowing and regulating medical marijuana. Michigan voters first approved Proposal 1 in 2008, and that was a voter-initiated law permitting the use and cultivation of medical marijuana. Proposal 1 received majority support in every Michigan county and was approved by 63% of voters statewide. And that proposal became the Michigan Medical Marijuana Act, or the Act, or MMFLA in this presentation. The Act was drafted by medical marijuana proponents, so we don't have the usual legislative intent reports that we might typically have. Often when we're trying to see what the purpose was of a statute, we can look back at what the legislatures actually were discussing or thinking about when they wrote it. We don't have that here, but we can tell the purposes of it from what the Act is itself. And those purposes presumably include creating a registration process for patients and caregivers and creating a procedure for patients to obtain treatment for various medical conditions. The Act allows medical marijuana to be used by qualifying patients. So a qualifying patient has an ID card and can possess up to 2.5 ounces of marijuana. If the patient has not specified a caregiver, then the patient may keep up to 12 marijuana plants in an enclosed locked facility, and those terms are defined in the law. So if you don't have a caregiver, you can grow it yourself. Qualifying patient means a person who's been diagnosed by a physician as having a debilitating medical condition, including cancer, glaucoma, HIV/AIDS, hepatitis C, Crohn's disease, Alzheimer's, and diseases that cause severe pain or nausea, and other conditions that have been identified by the Act or approved by the Department of Community Health. And there's a process actually for petitioning the state to recognize other debilitating conditions for which medical marijuana should be allowed. The Department of Community Health is the agency charged with promulgating rules for medical marijuana. And those rules are available online, and if you can't write down that URL right now, this presentation, the slideshow, will be available afterward. And those rules govern everything from the contents of the application, verification of information that's on that application, fees at the state level, registration, approval, and denial, complaints, revocation, and that petition to add qualifying diseases. It's only about 10 pages of rules, though. It's pretty manageable to read through. And there's also a link there to the website at the Department of Community Health that has the application and related information. Some rough numbers of where this is at. These are, as of last year at least, there were about 128,000 original and renewal applications received since the Act took effect in April of 2009. About 71,000 patient registrations issued, about 13,000 applications denied, and that doesn't add up to the higher number because the higher number includes renewal applications, and then also kind of an unknown number of caregiver applications. So something certainly that a lot of Michiganders are taking advantage of. To obtain an ID card, a patient must have a written certification from their physician identifying that debilitating medical condition and stating that this patient will receive therapeutic or palliative benefit from the use of medical marijuana. Prospective patients also must provide an application or renewal fee. The state always wants its money. The name, address, and birth date of the patient, the information for their physician, and the information for their caregiver if they have one. So a caregiver is a person who must be 21 years or older, and the department shall, I say can, but shall issue a registry identification card to the primary caregiver who is named in a qualifying patient's approved application, provided that each qualifying patient can have no more than one primary caregiver, and a primary caregiver may assist no more than 5 qualifying patients with their medical use of marijuana. So the caregiver, if you're a patient who's not growing your own marijuana, caregiver can provide that marijuana to you under the original 2008 Act. So applications for the qualifying patient and caregiver IDs are confidential. The department maintains a confidential list of persons to whom the ID cards have been issued, and that list is not subject to the Freedom of Information Act. Disclosure of confidential information, including by a local government official or employee, is a misdemeanor. So this can come up, even though it's a statewide registry, this can come up at the local issue if, for example, you get a FOIA request for information from a police cam, a body cam video, a police officer, or something else where there's some documentary evidence that you have been dealing with somebody who has a medical marijuana card. The fact that that person possesses a medical marijuana card is not subject to FOIA and is confidential. So that issue may come up at the local governmental level. Even with an ID card, a patient cannot possess or use, and a caregiver cannot possess or use marijuana on a school bus, on the grounds of a school, or in a correctional facility, and cannot smoke marijuana in any public place or in any form of public transportation. Also cannot operate, navigate, or be in actual physical control of any motor vehicle, aircraft, or motorboat while under the influence of marijuana. So that kind of conduct will not be protected even if you've complied with the law in terms of being a patient or a caregiver. So the purpose of this is really to make the medical use of marijuana an affirmative defense if you're being prosecuted for a crime involving marijuana. So if you get caught having marijuana, it's an affirmative defense that you have this medical marijuana card if the physician issued the written certification, if the quantity was not more than reasonably necessary to ensure availability. So if you're driving with a semi-truck full of marijuana, the medical marijuana card isn't really going to protect you there. And medical use must have been involved. So this was a medical use of it to treat or provide palliative care for that debilitating medical condition. If you are a qualifying patient with that ID card and the lawful quantity of marijuana, then you shall not be subject to arrest, prosecution, or penalty in any manner or denied any right or privilege, including but not limited to civil penalty or disciplinary action by a business or occupational or professional licensing board or bureau. And the same applies to a caregiver. So that was the 2008 Act. And then we did have some case law because there were some gaps in that 2008 law where the statute didn't really answer things, and that always leads to litigation. So State versus McQueen was a major case that came out in 2013 from the Michigan Supreme Court and held that at that time, which was before the 2016 legislation that we'll discuss momentarily, medical marijuana dispensaries were illegal because the medical use of marijuana contemplated in the 2008 Medical Marijuana Act did not include the sale of medical marijuana. So the 2008 Act allowed you to possess it and to use it, but it didn't actually allow anyone to sell it. So at that point, dispensaries, which are generally known to be a manner of being able to sell marijuana to other people, were illegal. Another case that came out of the pre-2016 time was this Turbing versus City of Wyoming case, where, like a lot of municipalities, the City of Wyoming was struggling with how to regulate medical marijuana. So it decided to prohibit all uses of land that were contrary to federal law because, as we'll discuss in a few minutes, despite being allowed under state law, medical marijuana is still illegal under federal law. So the city thought, well, we don't want medical marijuana, so we will just prohibit everything that's illegal under federal law. And the Supreme Court said, no, you can't do that. Local ordinances that attempt to prohibit the use of medical marijuana by prohibiting uses that are contrary to federal law are preempted by the Michigan Medical Marijuana Act, meaning even if federal law, even though federal law trumps state law still trumps local law. So the state gets to decide what the rules for that are. And if the state's going to allow it expressly under these circumstances, then a local government cannot prohibit it. The local government cannot prohibit something that the state specifically has allowed. A distinction that sometimes is lost is that really the 2008 did not legalize marijuana. It didn't say, okay, marijuana is good to go, do what you want to do. It protects patients and caregivers from prosecution if certain requirements are met, or protects them from other adverse actions. And it also, as I discussed a moment ago, did not legalize marijuana dispensaries. In fact, it doesn't discuss dispensaries at all, nor does it authorize third parties who are not caregivers to sell marijuana to patients. Enter then the Medical Marijuana Facilities Licensing Act, Act 281 of 2016, which sought to fill that gap into the 2008 statute. So the Facilities Licensing Act was signed into law on September 21st, 2016, but did not take effect till December 20th, 2016. And parts of it, as we'll discuss, are still not in effect. But the gap between September and December of 2016 was designed to give the state a chance to create a licensing board, which is the Medical Marijuana Licensing Board that will be able to administer rules related to this act. So the Facilities Licensing Act imposes a licensure mandate and provisions for certain medical marijuana facilities. So it creates and defines these 5 categories of medical marijuana facilities: growers, transporters, processors, dispensaries, which are called provisioning centers in the law, and safety compliance facilities. And I'll explain momentarily what each of those means. These facilities will be allowed if they comply with both the Michigan Medical Marijuana Act and the Michigan Medical Facilities Licensing Act. Unlicensed facilities remain illegal, and the earliest date to apply for a license is December 15th, 2017. What that means is if you have somebody who's a grower, a transporter, a processor, or a dispensary or safety compliance facility now, they're illegal. They're not yet permitted, even though this new law has been enacted, because they cannot apply for a license until December of this year. Municipalities have kind of a starring role in this new law. And a municipality is defined in the Facilities Licensing Act as a city, a township, and a village. The definition does not include county. Under the Act, Marijuana facilities may not operate in a municipality unless that municipality has adopted an ordinance, zoning or otherwise, so if you don't have zoning, it could be a police power ordinance, that authorizes that type of facility. This is an opt-in statute. It is giving the municipality the power to decide whether it wants those facilities in the township, city, or village. If the municipality does not adopt an authorizing ordinance, then the facilities are illegal in the jurisdiction. Illegal now, illegal next year after December 15th, 2017. Just illegal. Making that point here again, illegal unless and until the municipality enacts an authorizing ordinance. And because they're illegal, they will not be a prior non-conforming lawful use under the zoning ordinance. So if you've got somebody operating illegally now, they're not going to gain any kind of benefit or protection from that. If the municipality does enact an authorizing ordinance, then the facility still must apply for state licensing under the Federal Licensing Act. It's not sufficient to just obtain local approval. They must also have that state license. So a facility will only be licensed by the state if the municipality in which it's proposed to be located has enacted an authorizing ordinance. And an applicant facility must apply to that newly enacted state licensing board. Again, applications will only be accepted after December 15th, 2017, which allows time for municipalities to enact authorizing ordinances if they wish to do so. So the question we're often asked is, well, what do we do if we don't want these facilities in our jurisdiction, if we do not want to authorize them? And the answer is easy. You do nothing. No municipality is required to adopt an authorizing ordinance. So if someone is coming to your township board or city council meeting and saying, there is a new law and you have to adopt an ordinance allowing us to be a grower or allowing us to be a dispensary, they're wrong. There is no requirement that your municipality adopt an ordinance. You can choose not to, and then those facilities will remain illegal. As they are now, they will continue to be illegal. You have the power. The legislature has given municipalities the choice to do it or not do it. So what if you do want to authorize facilities in your jurisdiction? The answer then is to enact an authorizing ordinance, preferably before December 15th, 2017, because that's the earliest date an applicant facility can apply for licensure. There's nothing that would prevent you from doing it later. If at this time you decide not to adopt one, then the facilities will be illegal. They can't be licensed by the state, and they can't lawfully operate. And if you changed your mind a year down the road, you could enact an authorizing ordinance, and then they could get a state license and could come into the community. All right, as promised, here's an explanation of what those 5 facility types are. A grower is a licensee that's a commercial entity located in the state that cultivates, dries, trims, or cures and packages marijuana for sale to a processor or a provisioning center. You probably noticed, and maybe you've seen this before, the 2 spellings of marijuana. The state statute uses the H, everyone else in the world uses a J. So for growers, there's 3 classes. Class A is up to 500 plants, Class B is up to 1,000 plants, and Class C is up to 1,500 plants. And the statute does not contemplate licensing a grower that grows more than 1,500 plants. A processor is a licensee that's a commercial entity located in the state that purchases marijuana from a grower and extracts resin from the marijuana or creates a marijuana-infused product for sale and transfer in packaged form to a provisioning center. A provisioning center, what we've previously called dispensaries, is a licensee that is a commercial entity that purchases marijuana from a grower or processor and sells, supplies, or provides marijuana to registered qualifying patients. So they're still selling it to patients, either directly or through their registered primary caregiver. So we haven't gotten rid of the patient and caregiver, not at all. The use under this Act still has to comply with that original 2008 Act as well. So it's still only supposed to wind up in the hands of qualifying patients. This is not allowing retail use of marijuana. Not supposed to allow recreational use, I should say. So this includes retail sale to patients or caregivers. This is not intended to cover non-commercial property used by a primary caregiver to assist a qualifying patient. So if you have somebody who's a caregiver growing plants to provide to their patients, that's not intended to be covered by this statute. A secure transporter is a licensee that's a commercial entity that stores marijuana and transport it between marijuana facilities for a fee. And a safety compliance facility is a commercial entity. Again, we see that trend there. These are commercial entities that receive marijuana from a marijuana facility or a caregiver, test it for contaminants and THC, and return the test results and may return the marijuana to the facility. So let's say you want to adopt an ordinance. What should that ordinance say? You are able to specify how many facilities are allowed. So you can decide, you know, we will allow dispensaries, we'll allow provisioning centers, but only a maximum of 5 because of the size of our community, or only a maximum of 10, or we'll allow up to 5 growers. If you don't specify the number in your ordinance, then the state can approve as many people as they want to, or as many as apply and meet the state requirements. You'll also want to specify the location of facilities and other appropriate zoning regulations. So note though, under the state law, growers can only be permitted in industrial or agricultural zones. So your ordinance could not say that growers can be in residential or commercial zones. You can also pick which facilities you want. So if you only want to authorize growers, you can do that. If you only want to authorize provisioning centers, you can do that. If you want to authorize all 5, you can do that as well. You can also impose an annual non-refundable administrative fee of not more than $5,000 that's intended to offset the cost of enforcing or administering the provisions of the Act. What you can't regulate is the purity of marijuana or anything about the quality or what's in the marijuana itself, the price of the marijuana, so you can't tell people what they ought to sell it for, and you can't do anything that conflicts with state law. The use will still not be lawful. Even if you adopted that ordinance tonight, it's still not going to be a lawful use until after December 15th, 2017, and only if the facility applies for and receives their license. So why would you want to authorize a medical marijuana facility? Some communities want to because there's a lot of support in the public from it, and you have a lot of constituents who want it. That might be reason enough for you. There's also some monetary reasons. There's the administrative fee, up to $5,000, non-refundable, that you can require. It could potentially increase property tax if you, or add value to, let's say you have a vacant building and somebody's coming in with a proposal to turn it into a provisioning center, and you think it's a good location for that, and you think that you're going to wind up getting more out of that building if it's being used for something than if it's sitting vacant. There's also an opportunity to receive some state shared revenue. So the state is going to be taxing these, about 3% of gross revenue of what the facility is making. And they're going to take that and put it into a fund. And then municipalities in which a facility is located collectively will receive 25% of the money in that fund. And that money will be allocated in proportion to the number of facilities in a municipality. So if you only have one facility, you're not going to get as much money from that fund as a community that has 100 facilities. So it's all supposed to be proportionate. So state licensing under the new Act is only applicable, these requirements I should say, are only applicable to municipalities after December of 2017, and if you've adopted an authorizing ordinance. So what will happen if you've done that? We're after December 2017 and we're after you've adopted an ordinance, then you may receive notice that the state has received an application from somebody in your community to open a facility. Within 90 days after receiving that notice, you must provide to the state licensing board these 3 things: a copy of the local ordinance authorizing the facility, a copy of any zoning regulations applicable to the facility, and a description of any violations of these ordinances. So if you know that this applicant has already been illegally running a provisioning center for the last 2 years, that's something you could tell the state about. And obviously, if you get notice that somebody's applied and you don't have an authorizing ordinance, then you're going to want to let the state know, because then that application will be denied. Any information that you receive from the applicant related to the licensure is exempt from disclosure under the Freedom of Information Act. And any licenses granted by the state are exclusive to that licensee, and they would have to receive state approval before they could transfer or sell that license to someone else. All right, so that's the overview of where the state law is at. I think it's also important to keep in mind how this interplays with federal law. keep in mind that marijuana use, even for medical purposes, is still illegal under federal law. It's a Schedule I drug classification under the Controlled Substances Act, and under the Constitution's Supremacy Clause, federal law trumps, no pun intended, conflicting state law. In recent years, federal law enforcement has not heavily enforced this prohibition if the use is legal under state law. The Obama administration had issued some guidance saying that the federal government was not going to interfere if states legalize medical or recreational use of marijuana. However, the Trump administration has indicated that it may enforce federal drug laws even where state law permits marijuana use. Now, the preliminary comments through Sean Spicer have distinguished between recreational and medical use, suggesting that that enforcement action would be aimed at recreational use and not medical. But the fact is that both uses are illegal under federal law and could be subject to federal enforcement. So medical marijuana licensees should closely watch the policies of the administration on that. And finally, I wanted to close with some quick tips for local governments whenever you're dealing with a controversial issue, whether it's medical marijuana or urban farming or new wind or solar energy or anything where you get a lot of people involved. There's just a few quick things to remind you of. First is to make sure everyone on your board or council is familiar with both the substantive law at play as well as the Freedom of Information Act and the Open Meetings Act. FOIA and Open Meetings Act litigation is much more likely when you have these controversial issues just because of their nature and the fact that you have a lot more people paying attention than you usually would. So example of things to keep in mind is that you want to be sure to timely respond to all written requests for documents, even if it's not called a FOIA request, and comply with all FOIA requirements. And you've got to be really careful about not deliberating or discussing these issues outside of an open meeting. And it can be really easy to violate that. If you've got a 5-member board, there might be 3 of you standing around talking after a meeting and somebody says, hey, did you know we got that, that application for a marijuana facility? What do you think of that? Do you think we should do an ordinance, or what do you think? And you can get into a discussion among a quorum of board members without even really realizing that you are violating the Open Meetings Act. On a similar note, you should be careful to avoid hitting reply all on emails where you've got a quorum of the board or council on there. It might be that the clerk circulates an application for a facility and somebody hits reply all and says, well, I don't think that we should grant this for XYZ reasons. Again, you then have an Open Meetings Act violation that could come out through a FOIA request. So in all cases, you should be careful of those things, but especially when you've got these high-profile issues. You also may consider an alternative meeting location. If you're expecting a large crowd, it may be too much for your township hall or city hall, especially in some of our rural communities. So you might consider a community center, school, or other venue. And the Michigan Attorney General has issued an opinion saying that a public body must exercise reasonable efforts to accommodate members of the public who wish to attend, including reconvening in a larger room if it's practical. And you also may want to adopt a policy concerning public comment. So you can't limit the total time for public comment. You can't say public comment will be limited to 30 minutes total. But you can lawfully limit the length of each person's comments, such as each person may speak for 3 minutes. And you get out a timer, even if it's on your cell phone, and you strictly enforce it. But if there's 100 people who want to talk, you still have to let each of them talk for 3 minutes. So, but that's the way you can limit it. You can't cut people off so that some people don't get a chance to talk at all. Also keep in mind that the public's allowed to record and broadcast meetings, so you can't keep the news media out of there. And you can't require the public to introduce themselves or sign in, but you can have them state their name and address when they speak so that you can have that in the minutes. So in sum, I hope this presentation's been helpful in explaining the new law as it fills some of the gaps in that 2008 Act and vests control in local municipalities and provides that opt-in option for municipalities. So you should decide if you want to have an ordinance, and if so, what you want to be in that ordinance. And be sure to comply with the state law, Freedom of Information Act, and the Open Meetings Act when deciding this issue or any other controversial issues. And I'll quickly close with this little bit about our law firm. Foster's List Municipal Attorneys, we provide both general counsel and special counsel services, and not everyone's aware of that. So I wanted to quickly explain, for general counsel services, we can provide all legal needs or meet all legal needs for a municipality, everything from contracts and ordinance drafting, FOIA, Open Meetings Act, special assessment districts, zoning, land use, bonds, labor employment, litigation, and any other creative problem that your community can come up with. But in addition to that, we do provide special counsel services where you may just need our services on a specific issue, sometimes a high-profile or complex issue that hasn't come up before, where our specialty can assist you. And we collaborate with the municipality's general counsel to work with that. So we've been hired as special counsel on wind and solar energy issues, urban farming, complex property tax appeals, including power plant appeals, mining issues, and of course medical marijuana. So if you think we can assist you with that, please feel free to give me a call. My contact information is here. I see we did have some questions come in, and I will respond to those by email. And if you have any other questions afterward, my email address is here, lgenovich@fosterswift.com. Feel free to connect with me on Twitter or LinkedIn, and thank you again for attending. Have a great day.